Responding to emails and that's what in there.
What did you do after the telco?
I'm not going to sign that yet. I said, well, okay, just had this is not blocking or something.
Hey, Melissa.
Just want to connect you guys to each other. Up here. Nice to meet you. I'll meet you after the meeting. Answer all your questions.
I'm like, oh, and I'm like, okay, I don't have time to college. You're not going to stick out or anything. I don't know. I always look at the
Oh, yeah.
and he's standing in front of us, so he knows we're going to stare at him, right?
Yeah.
I'm sure excited to go. Oh, yeah. Just a lot of our visibility is just done when it's done.
Yeah.
I'll see what I can find out. Yep. Good morning.
Good morning.
Grab a seat and we'll get going. For these. Hey, Eric.
Yes.
You have time to talk to Brad Knotson.
Yeah.
Good morning. Thanks for being here. Dennis, you want to take a quick second?
Yeah. Hello everyone. Dennis, Freedom Home Warranty. If you don't know me, it's a great time to put a home warranty on a house. If you have something that's pending right now, we can add it into that. If you have a listing that's coming up, we can put a seller's coverage on it. It's free, absolutely free. If you're a seller, you can provide value, which we can talk to you about. And I'd love to help you that way. If you have a seller's coverage with us already, and you have buyers, let me know so I can get that transferred over to a real warranty for the year when they close. And just be able, I'd love to help you guys out and just be available to you. So that's it. Thank you.
Thanks, Dennis. That was easy. Kim, you're providing a CD today.
Yes.
Those that are just a thin crowd, and they figured the week of 4th of July, it's always an excuse to take it off for realtors, right?
There we go.
It's sunny, it's raining, it's a day off.
That's right. Very good. I don't really have much to say other than thank you guys. I'm going to be doing a tally of all of the open orders that we've had that have been directed by More Realty. And I'm going to figure out how much I'm going to give to the More Gives Foundation.
Oh, nice, thank you.
So, yeah, and thank you all. Oh, there you go. Thank you all for all your business. And if you haven't worked with me yet, just give me a call. Let's sit down and chat and see what we can do to help build your business. So, thank you.
Thanks, Kim. Eric Kroll, you just walked in, you wanna take a quick second?
Good morning, everybody. No CE today from us. We thought it would be like turnout. Some hardcore people are here.
Yeah.
Next week, one of the ones that we've been asked for is reverse mortgage. So a week from today, we're gonna do a CE hour on reverse
Do
mortgage.
I have that one?
Let's look at
Okay,
it.
yeah, cause I know I have.
I've got it all
there's another
scheduled
one.
up, yeah,
Okay, just
yeah.
let me know.
All right.
Thanks, Eric.
Yep.
Anyway, who's here for the first time and guess? I'll introduce Court Balky back there. He's getting his license, trying to decide where to go, put his license. Gonna take the test here soon, right?
Yep.
And I've known Court since '96, right?
Yep.
We were in the telco days together back, that's where my life prior to this was telecom, and you just left telco.
Yep.
Slow learner. It took 12 more years than I did. I bailed when I could. But yeah, so be nice to Court. And let's see, you had your hand. This first time doing it? Did you want to introduce yourself really quick?
Yeah, I'm Wendy May. I was with Windermere for 5 years, KW for 3 months, and here now.
KW Leeds is 3 months.
Well, 4 months.
4 months? That was a
Yeah.
quick tenure.
And,
Yeah.
You must have got your first check.
Yeah. Yeah, I'm signed up for that. Yeah.
And are you first time? You just visiting?
Yes, I'm from Oregon Realty. I've been there I was there for about 10 years.
Oh, okay.
My name is Luis Serrano.
Oh, okay, yeah. And you just joined us in Washington? I think?
Yes, also,
Okay.
I just got a license in Washington.
Okay. And you're with us in Oregon now too?
Yes.
Okay, well, welcome. Yeah.
related to a dog?
Yes, my brother.
Oh, Don Serrano, your brother?
Yes.
Oh, cool. Okay, you are a slow learner too. The Don was like hire number 4 for us.
Wow.
And we're at 316 or whatever, so. Oh, well, welcome, good to see you. Anyone else? Nope, okay.
Oh, one more thing
Yeah,
I wanted
Kim.
to interject. Today is Mary Jo McGovern's 60th birthday.
Oh my gosh.
So if anybody just wants to embarrass her, reach out, just give her a little voicemail or an email or something like that. Did I say 60th birthday? That's okay, because mine's coming up in 6 months. So, but yeah, and if you have an escrow for a birthday present, that would be awesome.
Oh, jeez. Kim's always selling. isn't she?
all like to.
She's always selling.
Yeah.
Be a little bit different today because we're thinner than usual on our crowd, but glad you made it. And you are getting a CE for those that walked in a few minutes ago. Be sure and sign it's over here with Marvin right now. Be sure and sign it before you go so you get credit. Any questions before we get going? Anyone have anything they want to ask? No? Okay. Easy
Oh,
crowd.
one more thing.
Yeah.
I'm sorry. I know, I always have something. Okay, so I know a lot of times I talk about, I love to see people with like more realty shirts and things like that, hats. And so, what's the?
Hey, James, stand up for a second.
James, turn around and
Look at
show
James
me
did
that
with his shirt.
awesome.
This is an expensive Goodwill shirt, high quality. Yeah, it's pretty easy to do, so.
So he
Hey,
has
Melissa,
these, more
should have that
different
sample.
setups, and they have the
That box.
loyalty logo right there,
You
which
wanna-
you have,
You wanna-
right? And what did you say, it's $10 a shirt, if you wanna take a shirt?
Yeah, you have to send them like a PDF. It's like $45 to set it up however you want it, and then $10 per shirt. Mine is in Newburgh, Dormer, so they probably have other ones close by.
I would love to see.
Scott Galloway do that too?
You did, yeah, we've had a few people monogram some shirts.
Being you set it up, can we just get it done for $10?
Probably.
Yeah.
Talk to them, give them my name, and say I want that one. Seriously, try it. I don't
Okay,
know.
what's really funny about this is he'll spend $5 to save $1. He's Mr. Cheapskate. Melissa came across a closing gift, just wanna take a few seconds to show you something new you can do. So I have all the details, but let her, go ahead.
So this company is called Save the Day Seasonings. They do the outdoor shows here in Portland all the time. So I met them a couple years ago, and they have a new program that they'll do for realtors. Well, they'll actually, this label's kind of messed up a little bit, but they'll label the box as well as they will put labels on the back of the seasonings. Now, all of these seasonings they make custom, and so what a great way for your clients to remember you every time they're cooking. They'll put a special message on there for you as well. So there's different options. You have wooden spice racks as well that they will do for you for your clients. I do have a list here there's a price list that I can hand around, as well as they have this card that talks about their seasonings, what's in them, as well as recipes on the back. And on these cards will come with your seasonings. They can put a private message on there for you as well. So this is, I think, a great closing gift for clients. It's something that they'll remember you every time they're cooking. So I will go ahead and pass these out if you guys are interested.
Can I just make a comment too? They have keto friendly, they have no sugar,
Yeah,
some of them,
yeah.
no salt, and I use those all the time.
These
Oh,
ones
okay.
you do, the Save the Day?
Yeah.
Yeah, they're amazing. They're based out of Idaho. Their shipping is very quick, so they can ship them to you and you can take them to your clients, or they can ship it directly to your clients for you. So, all right.
You
I
wanna
can
do
pass
anything
them
there?
around if you guys
Huh?
wanna take a
Touch
look at the
anything?
spices.
Cool.
I mean, I can touch on a few things if you want.
Well, I can, I
That's
have
fine.
things.
Go
You
for
want-
it,
You
go
wanna
for
catch
it.
up later?
Yeah.
Okay, we'll come back. So, wanna jump into a couple of meat and potatoes topics, kind of the CE, things. By the way, I have to leave at 11, so those are used to having access to me at 11, I won't be here, I got a quick doctor appointment I gotta run to, so I'll have to leave by 11. But we'll be back. So, this has come up more than once lately, this is kind of a training thing. The client does not make an earnest money deposit, now what? That was sort of the topic. So what are the implications if a client does not make their deposit on time? Fire. Is that it?
Out of contract.
You're out of contract. Can be terminated by who? Yeah. Is it technically out of contract and effectively over?
No.
It's effectively over, right? Unless there's arrangements somehow made verbally, or not verbally, in writing, that we're now gonna accept this after closing, or. How many have dealt with this before, where someone just keeps delaying it and delaying it? I mean, I have several times. It's pretty common out there. So what happens, this has happened literally with one of our agents over the weekend. Client did not make the deposit and decided to terminate instead. And then the seller says, we're going to sue you for the deposit.
Yeah.
Can they do that?
Yes.
Show of hands, yes they can. Show of hands, no they cannot. Chickens.
Yeah.
Not even how many don't know? Seeking to learn, okay, that's fine, fair enough. So why can they sue? Deirdre, you said adamant yes.
Pardon?
Why can they sue for the deposit?
Because they're a breach of contract and, sorry, I was paying attention to the spices when you asked.
Sorry, I can come back to you.
Pardon. Yeah, they're a breach of contract and they have a right to the earnest money. I mean, because time period is coming on and, they breached contract.
How many people have been through this where a seller has sued and got the deposit? Anyone ever been where the seller tried? You have?
Yeah.
Did they get it?
No.
And how'd they get it? Did they try to go to small claims or what?
Yeah, they threatened it and I negotiated around it.
Okay, always the best if we can, right? Becky, you had your hand up?
I was just gonna say, it's the only remedy a seller has, is the earnest money.
Yeah, so in the contract, right here, under deposit, I'll make this large. There's earnest money deposit, section 25, right? And you agree to make a deposit of $4,000 within 3 bank days of mutual acceptance. And on day 4, you haven't made the deposit, okay? And the seller could sue for that. And the reason they would prevail is this verbiage down here, earnest money payments to seller. Seller assigns and accepts the agreement and title is marketable, so the representing title is marketable. And, go down here to line 328, buyer fails to timely make a earnest wire transfer of buyer's earnest money deposit, then all earnest money paid or agreed to be paid shall be paid to seller as liquid damages.
Oh, wow.
I hear some people like, oh, I didn't know that before. Yeah?
We had one recently that they did that, they didn't pay the earnest money, but like an hour before we were supposed to get it, I get a notice from the agent saying that they looked at the title report and were unhappy. Now, the truth was, they had a sale pending on their house and it fell through, and verbally she told me that, you know, that's why they're not doing it. But I did get an official notice.
Yep, that works. But if you just don't make the deposit and then just terminate and expect your deposit back, you're at risk of not getting that. So the right way to terminate a transaction is something like that. If you don't wanna make the deposit, do it before the deadline, and then terminate based upon the title report. What else could you terminate on the? Have you had your inspection?
I don't.
So can you use the inspection in the contingency? You can't, what else could you use?
Seller disclosure.
Disclosures? What else?
Lead-based paint.
Lead-based paint, anything else?
HOA docs?
HOA
Financing.
docs, what's that?
Financing.
You can just find, it's a little harder because you have to prove it, you have to have a lender cooperate and say, I think you don't qualify.
So with like disclosures, it can be anything pretty much though, right? I mean,
So you don't have to give a reason with disclosures or title
Okay.
report. You can just say, I reviewed it, I terminate.
okay, got it.
Who did we do that for, Heather? Where's Heather? We did that for you.
Yesterday.
Yesterday, we had somebody who, this inspection was scheduled yesterday morning, deposit had been made, inspection was scheduled yesterday morning. The buyers canceled the inspection, we're ready to terminate. And we've only been under contract like 6 days, something like that. So can you just go, we changed our mind, we want our deposit back? You risk maybe not getting it, right? There's a risk. So, kinda like Joe said here, we terminated based upon the property disclosures. And all you say is we've reviewed the property disclosures and hereby terminate based upon the contingency timeframe.
Do you wanna go over the addendum that you terminate and it's just for the seller property disclosures?
I can bring that up, yeah.
Can I ask a question though, Paul?
Yeah, Becca.
I've always heard that the seller can't put their house back on the market if they're in.
That is not true,
I
so.
thought you said that one.
No, that's not true. So you need to be aware that, and this happened from a Cascade Sotheby's PB, reached out, this is a couple years ago, reached out to me and said, we've terminated and the deposit and there's a dispute, you can't make that property active again. And I said, and in my mind I go, wait a minute, you're a PB? And at Cascade Sotheby's? And I said, well, read line whatever. Oh, okay, I didn't never notice that before. So, it's not hard to be really smart in real estate relative to your peers. Sometimes, all you have to do is just get a little training. But yes, absolutely, if a buyer terminates, upon sending first of all, does the seller have to agree to terminate? Not at all. It's a what?
Notice.
It's just a notice. We've terminated. And it doesn't take a seller to agree for me to terminate. I can just terminate. And when can the seller go back on the market? Immediately. Do they have to wait for a deposit to be resolved?
No.
Not at all. It's a separate issue. Right? So, good thing. So, into zip forms here really quick. Yeah.
So one of the biggest things I've done to avoid this is make sure that my buyers understand that the earnest money for business day at 5 p.m. is not a suggested timeline. It's actually a big deal.
It's a contract, yeah.
Because what they do is they say, oh, I can make it, or they this, and you need to make sure that they're accountable to that. And I don't think a lot of agents impose how important that is. And then they run into this last minute, oh crap, I can't get there, and then they've got to extend or whatever. So having that when you write the contract, state how important that is, and it's a set thing that keeps them and could get them in trouble.
Yep. So, words
Matter.
timelines matter, right? So yes, it's not a suggestion,
It's a thing.
it's a contract, right? And if you miss those timelines, either that contingency closes or the contract's effectively terminated.
Because it used to be that we would just maybe facilitate ourselves, we'd grab the check and go, and now that they don't let us do that, you've got to really impose on them.
Who doesn't let you do that?
Huh?
Who doesn't let you do that?
We don't in Washington.
So in Washington, they don't let you do that, but in Oregon, I suggest I've never said you can't at company, I'd suggest you don't.
That's what I meant.
Okay, I just wanna make sure there wasn't a rule I missed.
No, you can, I just don't think it's smart to.
It's not a good idea. And why? Just to not go over that too? Why is that not a good idea?
Liability.
Yeah.
Liability, I now have someone's check for $5,000. And I have their account number, their address, and now I have an offer with some other information. I've got all this stuff and I've got their checking account information in my hand. If there's a problem with that checking account. So I just don't want to touch it. Don't even want to see it. Here's where it goes. And I've never had pushback on that.
So Paul, you were talking about in writing, so if I terminate, let's pretend I'm out in Timbuktu and I can just get my email to go out, but I can't access my forms, and I write and say, we have terminated the contract, please acknowledge receipt of this, and they reply back, received, we understand. Is that legal then?
That's still a termination.
So I am good with that, if the worst case
It's best to
scenario.
do a form if
Right.
you can, but you just say, hey, we are away from the computer, I can't get signatures. I will forward that to you as soon as I get it, but this is our official notification that we hereby terminate this transaction. Please let your clients know you're free to go back on the market.
Should I
Something
upload that
that-
in Disguise Scope
Oh, yeah,
because it's in there?
absolutely.
Okay, so.
Yeah, you better
I'll
put
do
that in Disguise
That's
Scope.
what I hear you saying, is I.
Yeah. So whenever you call the agency, I've told this before, and ask questions, they always end the call, she ends the call by saying this to me, document, document, document. Cause it really doesn't matter what you say, it's matter what you can show.
Right, there's just one thing I didn't upload and I
Yeah.
just thought about that.
What's it called, Melissa? Remember what you say?
I can't remember the name of it.
It's termination based upon,
It's towards the bottom.
You don't have to
I can't see
upload
from back here.
anything, if you can just copy the file.
yeah, just copy the file, yeah, forward it to the email. Oh, where is it? You said it's there, Melissa, but I haven't seen it yet, I've only seen the termination.
Yeah, we used it yesterday.
Here's a termination agreement, ideally, you could get. And they've now split it into two, because the top side is termination, the bottom is the distribution of the funds. And so they can sign this, but not sign the bottom.
Yes.
Yeah. I'll let you find out, Becky, unless we'll come back.
So all you're saying, that's all inclusive now, the termination and then distribution?
Yes, but like.
It used to be not that way.
No, it was different, there was only one signature, there was a termination and the distribution, and people, I'm not gonna sign that, so we're not terminated, yes you are, it's a notification. Seller does not need to agree, okay.
And that's the only document you need then for the full termination?
Well, she's trying to find a form they used yesterday really quick that I was gonna point out, but yeah. You can always do a separate addendum that says, we've reviewed the property disclosures, we hereby terminate based upon our findings, we're unsatisfied. And back to your question, do you have to give a reason? No, you don't. I reviewed them, there's nothing in there that says you have to give a valid reason. I just review them and I terminate. And the state agency is very clear that these documents and agreements are very clearly written for the buyer benefits, to protect the buyers.
You also, per the original contract, it specifically states under that clause that you can terminate before they send the disclosures. So you don't have to have reviewed them, they may just not have sent them.
Yeah,
yet.
right.
And you can still send that same termination, which I believe is what she's looking for, and I've seen it. It
Oh, the
says-
revocation.
Yeah,
Yeah, it's a revocation.
Based on disclosures, we're terminating.
Yeah, it's
It's
a buyer's
exactly right.
notice to seller of revocation and demand for buyer.
Okay, so what's it
Or
called?
for refund.
It's called buyer.
It's a buyer's notice to seller of revocation.
There you go.
There we go. So I haven't used that form before, so I'm learning too, I learn every day. The great thing about real estate is it's never the same day twice, never the same transaction.
Is this a newer form, this particular one?
I don't know how new it is, I've never used it, but it's current as of 2019, I don't know how long it's been around. But it's buyer notice of seller revocation and demand for refund.
4 years at least.
Is
What's
that
that?
for any reason?
4 years at least.
4 years. What's that?
I was gonna say, is that for any reason, not just the inspection disclosure?
No, this is just the property disclosures.
So here's what it is, pursuant to ORS 105.475, blah, blah, blah. The buyer hereby gives written notice of revocation of buyer's offer based upon buyer's disapproval of or seller's failure to deliver seller's property disclosure statement. Accordingly, demand a refund. So, and then you have to show where you delivered it. So, timeframes do matter, you wanna track them and be aware of them. Because, right, like Joe said, even though the deposit has been made, there are other ways to get your money back if you just do it right.
And
Yeah.
that's actually a really good thing to use this form, because most of the time you want to terminate it, and then you ask the seller to sign to get his money back. They will say, no, I'm not gonna sign it. So you cannot get the money back. You talk to the title company say, no, we need to get an agreement.
Mhm.
But if you use this form, you send it to them, they will still say the same thing, but you say, look at it.
You've already
Talk
agreed to it.
I can talk to an attorney. And then, there's a time I try it, they really talk to the attorney for the title company. And then they say, no, you just have to get the money back to the buyer.
Based on this form only?
Yes.
Cause a lot of what he's saying, a lot of title companies want a termination,
Yep.
plus their own internal form to release the money.
The last time.
That all parties have to agree to.
There's a time I call you and ask you, hey, can I get this money back? You say, no, right?
I did?
Yeah.
Oh, okay.
Because like, because you said we have to get the agreement both side by seller and buyer.
Yeah.
And I sent this form to the title company, they also say, no, I need the form. Both.
And you leaned on them and they finally caved.
They finally look it up and do all the.
Good, I didn't know that, so,
Yeah.
but not every title company treated the same way.
Can you repeat that?
No, Kim, it's too late. You need to pay attention.
I wanted to see what
You need to pay attention.
I was talking to Tracy about.
I'm just kidding, I'm kidding. So, termination of a contract, deposit disbursement, title wants to see a termination agreement and their own internal form, typically. Here's our own internal form, you're agreeing to hold us harmless, we're gonna release the deposit. What he's saying is he provided this form only to them.
And they wanted the
And title said, well, we wanna do our own other form, and the sellers were refusing to sign it, and he pushed back on them and said, read the form.
Yeah.
They've all signed it, so they finally released deposit based upon this form. But that's great, but that's not a guaranteed solution every time.
Yeah, at the beginning, I forgot which title company, they were arguing with me, and they say, no, these things, and then I pull up the law, the statute, or the statute, and then their attorney look at it, yeah, we need to give that.
There you go. Because had the seller, all parties not signed this form, you wouldn't have been able to do that.
The seller never signed.
Well, the seller never signed this one?
There's no spot for the seller.
Yeah.
Oh,
right.
Oh,
Bottom
that's right,
right.
okay, gotcha.
Seller's agent.
Oh, agent, yeah.
Okay, I got my glasses on.
They released it even without the seller signing anything?
That is at the top, it's just like.
Well, good for you, good for you. Push back on title company. Good job. Cause they're so adamant about, no, we gotta have this or else, we don't wanna get sued. Good job.
But they didn't ask for the termination as well from us.
They asked for the terminations, they want the terminations, the last one we see.
Yes.
They want both seller, buyer signature on it.
So they want, if we deliver this, they want a termination
So I
agreement as well.
decided to use this form.
Yeah.
I said I go for the seller disclosure, we just revoke by the disclosure.
Seller's
So-
disclosure one's almost easier than inspection.
Yeah.
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 That's a fun little secret. We like to use inspection contingency.
Because on this one, I actually look up the statute, the Oregon statute law. It's really clear, you just have to pay back.
Yep.
Even, I mean, title company, escrow, they cannot just against the law.
Good for you, I was
Yeah.
proud of you, good job. Did I see your?
Oh, and I
Yeah.
just wanted to interject too. I know sometimes escrow, they seem, the escrow officers seem to be really stern about things that they can do and can't do, and writing up, things that attorneys should be doing. But what they're also doing is protecting you. They're not just doing it because they don't wanna do it or they're too busy. So, it's really good to always ask questions and say, why can't we do this? But, sometimes they, you could get into trouble. Like,
Yeah.
there could be some legal actions if it wasn't done correctly, right, against the agent.
Yeah, but it's really not between the agents.
Right.
It's buyer and seller.
Yeah.
The people, the real person at risk that they release is the escrow company. We're not.
Right.
We provide the documents, and kind of we're not making the action.
Right. Well, I was just talking in general too.
In general too, yeah, they're trying to
In
protect
general,
and.
They come sometimes
yeah.
they can seem like they're being judgy and they say no, but.
No, but I understand why they, even if they would be, because it only takes one person to say, you release the deposit without authority, I'm suing you.
Right.
And then to win,
Right.
for some reason, yeah. So, go back to this example I gave where this client said, you didn't make your deposit, we're gonna sue for the $4,000. How do they sue? Do they go hire an attorney? They said we're gonna sue for that and all the court costs and attorney fees.
Small thing.
Okay, why is it small claims? But the purchase and sales agreement says mediation arbitration.
But isn't that, the agents agree to that, but it doesn't mean that the buyer and the sellers necessarily agree to that.
Small claims requires mediation beforehand.
So, small claims, what's the dollar amount of small claims in
I
Oregon?
think it's 10,000.
10,000 or under,
It's
small
5
claims.
in
And why is that?
That's 5 more.
Yeah.
Why do you suppose they're at 10,000?
So we're not flooding the courts with.
We're not flooding the courts with things that can't, I've had to go to small claims several times with people. What they make you do, you show up on your appointed time and everybody's there for that, there's like 60 people there. And they say, okay, you two go to that table, you two go to that table, you two go to that table, and try and figure it out. 95% of them get sorted right then. And they go back to this. If you come to an agreement, go to this desk and tell them what it is and we're done. If you can't come to resolution, go to this desk and tell them you can't resolve it and you'll get a scheduled court date. So they make you sit face to face. What if one of you doesn't show? You lose automatically. No show loses. So first of all, that's small claims. And so you think about if you didn't have a small claim threshold, how many things would be going to in front of it? I mean, it'd be staggering, right? So, but back to why it's small claims and not mediation or arbitration, section 38 point there. So anything under 10,000 has to go to small claims. So if your client freaks out like, oh my gosh, so now this client's very concerned, and I said, well, look, here's how this works. Is first of all, they have to go to small claims. You can't go to court. The attorneys, if they want to go below their money attorney, that's fine, but they can't recover it. All they can recover is they're limited to the deposit. That's it. Excuse me. And prevailing party fee of like $100 or something. So it's not like they win the lottery by going there. Secondly, it's going to take some time and months, and it's not a guaranteed outcome. Even though it says this up here, I have yet to see someone enact this. You didn't make the deposit, we're suing you, and then win. I've never seen him initiate it. Now that being said, sure, as I say it, someone will, right? But maybe someone's heard of it, but I've never heard of a seller doing that and kind of move on with life. The other challenge too is that by the time you get to court, I may have already sold the home and therefore not. So now you got all these complexities. You've already been made whole by somebody else. You sold it for more and whatever. Okay? Comments, questions, things, experiences you want to share on this? Okay. I want to shift to tenant. Okay. Nothing's making me scratch my head more lately than this new tenant law and how it impacts us and trying to figure out, no, wait a minute, what about this? What if? How does this work? Right? So if you haven't attended the landlord-tenant law classes, C-classes, we're gonna have more of them. Yeah, Kim.
Kevin Ike, he just did one himself. It is an incredible class. He really goes into detail. He'll give us the PowerPoint. I just had it last week, and
he sent it to me after his class and said, do you want this? I said, sure.
Yes, oh, definitely. And it's a really good one, so let's get that scheduled.
Yeah, and I called Kevin Ike, one of the attorneys who's been here to teach it, and I said, thank you for the PowerPoint. But I said, but I just want you to know that when they have the CE hour, in the end, here's what we're telling our agents. If there's a tenant involved, and he's writing an addendum, an attorney's writing an advisory addendum to give your clients that says if you have a tenant in place, whether you're a buyer or seller, we hereby advise you to seek competent legal advice or talk to your property manager because there's implications and timeframes we don't understand.
Yeah.
And that's it. How should you be guiding your clients about your tenant, about evictions and about the thing? What should you be saying?
Nothing.
What I just said. That's it.
Can I give an example?
Yeah, I'm sure examples come over years, yeah.
Yeah, so, anyway, so I did a duplex last summer to a good friend of mine, and, we were going to, as you know, in the check in the box saying that the sellers are responsible for removing the tenants, and that's what we get agreed to on the purchase. As we have progressed, the listing agent came back to me and said, yes, the tenant's willing to stay with the increased rent. Now, this tenant had been there for 15 years and never had increased the rent on it. They were paying $600 a month for a 2-bedroom in Selwood. So, but they had agreed to come back to $1,200 per month for rent. And so they went out, they got the signatures of the tenant, and sent us the documents, sent everything was agreement, so we had decided to go ahead and accept the tenant. 2 months later, the tenant went into a lawyer, and then, check this out, the lawyer looked over the contract and he says, oh no, this isn't valid. They didn't give you 90 days of notice, they gave you 88. So it was null and void. He went back to $600 a month. That was, actually, I think it was in October. This June is when his lease ended. So my buyer was out $600 a month since.
And that was before the tenant law changes. Yeah. So it's even different than that now. So I just talking to Stella this morning. Here's a scenario. Tell me what you think. I own a condo that I'm currently renting out, and I want to sell it. Can I sell it to a private party? Who's going to occupy it?
Yeah.
As our own?
Well, it depends if there's a lease and when the lease runs out.
Okay, yeah, that's why this is confusing. Can I sell it to a different investor who wants to keep it as a rental?
Yes.
You can't.
can agree to keep the tenant at
You
closing.
can,
The tenant law, Kevin Ike, I mean, and we've checked on it, tenant law says if you have a tenant occupying a property, I cannot sell that to another investor.
even if they give them a 90 days
I'm telling you, I mean, she triple checked with Kevin Ike and,
The only way to sell it then is to evict the tenant after the lease is out?
or for cause.
Well, yeah.
Or, here's the other weird twist, if I get an offer on this property to close, I can now give notice to terminate, the 90-day notice. There's something about that too.
Unless they're under a lease.
So you can't give a 90-day notice until you have an offer.
Until you're under contract, but I can't sell it to an investor.
You can't give them a 90 days notice if they're under a
So,
lease.
right, sell it, you read it, you've seen it, and Kevin Ike said,
I've got the House bill, it says it must be being sold to a person who intends to.
occupy, if you have a tenant in there.
Just for townhouses?
Has to be
A
different.
rent, the tenant, it's not a townhouse or a
Doesn't matter if it's a
This is
condo or
tenant.
anything.
Yeah.
This is a tenant law. So my point telling you this is I've had several cases, things like this, right? You call an attorney, like, okay, I'm hearing this, and they go, I don't think that's right, let me look into it. They'll come back and go, oh my gosh, you are right.
Wow.
And that's exactly what happened with this one, yeah, go ahead.
So is this Portland or is this?
Oregon.
Oregon.
So, yes,
The solution is negotiate with the tenant. A cash.
okay, think about what happened here. If you negotiate with outside the parameters of what state laws allows, you put that in front of the right attorney, there's potentially
The-
thousands,
yeah,
if
the
not
tenant
tens of
can
thousands of
win.
dollars of problems for you in this new
Yeah.
tenant law.
If they agree to leave and hand me
Doesn't
the
matter.
keys,
Even
If
they
you do it
agree.
outside the parameters of what's, so let's say, yeah, we'll agree to leave in 60 days, even though you only gave us 10 days notice or 60 days notice. They can still come back, attorney can come back and say, no, that wasn't enough time, we're gonna unwind this. You have to, yes, you agree.
This doesn't make sense, for example, if you think about an apartment complex and someone wants to sell their apartment complex to another investor. There's no way that they're gonna be able to evict all of the
There's different
people.
provisions and different things. Here's my point in saying all this, okay? When you have it, now, I'm still trying to I'm not even gonna try and understand it all.
Yeah.
Cause I keep hearing these new twists and turns like, wait, what? That makes no sense.
They're making their own rules.
And people are interpreting it, attorneys, and even when, who was here for the training we had from OAR, the online one, even they were like, we don't know how this is gonna work yet. This is the Oregon Association of Realtors saying this. The attorney who helped craft some of this stuff, like, we're not even sure how it's gonna look. So my point being is, if there's a tenant involved, do not guide them. Buyer or seller. Say, yes, we want 30, we say what we want in the offer, but just be prepared, there's gonna be an advisory addendum. You need to go talk to a competent attorney or property manager if you're a seller, and make sure we're doing this correctly, and then let me know what they say. And I'm happy to interject there, yes.
So I have that bank foreclosure that has a tenant. They're based out
I don't
of
know.
Florida.
I don't know.
I need to tell them that they need to figure this
I don't
out
know.
because they want them out in 30 days.
Yeah, I don't know, and banks don't play by anyone's rules,
No, they
right?
don't.
And
But
so
then
the
I'm
pro-
having to serve the
Okay,
tenant.
so you know what I'm gonna tell you? Talk to competent legal advice.
Yeah.
There's too many twists and turns, too many misunderstandings, too many, you ever hand it, Morgan?
I do, but I'm waiting for you.
So even in that case, you should talk to Chase and say, look, the tenant laws here have changed significantly. Here's someone here locally, an attorney, and you might wanna make sure you're clear, good to go here. Cause what you should not be doing is putting yourself in a place to interpret this for them.
No, and I
At
don't
all.
want to.
And no matter what I have just said about this investor or whatever, don't go translate that to your client. Say, okay, you're an investor wanting to buy this, let's write an offer, but you better go, there's a tenant involved. You better go talk to a competent lawyer to make sure this is gonna work out and what to do about it. They've added this layer of complexity to transactions in real estate that they haven't been able to predict and we don't quite understand. The safe play for us as realtors is to punt them to, well, I don't wanna spend for an attorney, well, sorry, cause think about this, I wanna be evicted in 30 days, well, by law, they're allowed 90.
Mm-hmm.
Okay, well, my rate lock expires in 30. I'll accept the tenant after closing. Okay, where are you gonna live for the 60 days after that? Like 60 days. And, does that create a new tenant relationship?
Yes.
Maybe, I don't know.
Yeah, right, exactly.
I
Does
just-
it
that's
start
the point,
over?
I don't know, so,
Yeah.
so when you're a buyer or a seller, look, set up an appointment with an attorney to talk this through. I'm happy to be on there, but this, you know, you need to foot the bill. But there's a tenant involved, and the laws are so, and the problem too is the potential penalties are staggering. And that's the other thing. If it were a couple $100 risk, whatever. I mean, lawyers $300 an hour, right? Okay, I'll roll the dice. It's kind of like the healthcare thing. What's the penalty is less than the premiums. So a lot of people don't get health insurance. I'll pay I'm paying money. I'll just pay the penalty because it's cheaper. If it were like that'd be different. But the penalty is severe if you do it wrong. So, yeah. Okay. So, oh yeah. Okay.
Yeah. I've got a tenant that we went on a month, and do I have to give them? They give me 30-day notice to get out.
Hey Marvin, I suggest you talk to a competent legal counsel. That's the level of this is.
Yeah.
That's it. Do you have an attorney? Sure, here's 3, give them a call. Yeah.
So the concern is that most of the time you try to negotiate with the tenant agree to, say, leave the property. It sounds like now they still just get like, after they gone, they come back like, 2 months.
We do not want to negotiate anything, right? We put it back on the seller.
Yeah, but I mean, say even just talking in general, even both of us are like landlords ourselves too. So you talk to the tenant, and then they say, okay, I'm gonna just leave. I just hand you the
If they agree to just leave,
but it sounds like
I'm still gonna say, you better talk to an attorney to make sure you got your paperwork in order to make sure that they can't come back on you.
No, they can't.
But it sounds like now they can just, even after a year.
I don't know, but there might be a way. It's to my point, is there could be a way, and there could be a way for the bank, there could be a way for apartment complex, there could be a way. It's not up to us to find out what that is.
No.
That's my point. That is outside the purview of your license and what you should be doing. It is that complex.
My brain's sitting here saying, I intend to occupy it for a day. I intend to occupy it for.
Like an investor?
Eventually, yeah.
Yeah, there's games that can be played there.
What can you do?
What tricks of the trade?
Yeah, there's more to learn, but even the attorneys are learning as we go. But the problem is you have, anyone here a lawyer? A lot of bottom feeders out there who are looking for a way. How do attorneys make their money? Hourly? $300 an hour is a cheap one. That's about $5 a minute.
30% of a settlement.
30% of a settlement, but how do they really make that money? By stirring up contention amongst people.
By helping make the new laws.
Yeah, writing, and who writes the laws to protect the attorney? Who writes the laws? The attorneys, and they write them to protect the attorneys, right? They do, and that's admitted by many attorneys. So I don't want to get too far off in the weeds and all this. In 1042, what's that?
Too late.
But there's only so far you should go. There's a tenant involved. Here's this advisory addendum. As a buyer and a seller, write your offer the way you normally would. We want the tenant vacated they want to vacate in 30 days. That's the way the paperwork's written. There's going to be some counters in play. You have to expect it. It's just related. And it has created a level of complexity that we no one really quite understands yet with the tenant involved.
And remember, tenants can be family too.
Yep.
Yes.
Doesn't matter.
So the seller's family could live in it. I was dealing with an estate. A daughter was living at the estate, her mother passed away. The other sister was handling the estate, but the daughter that was living at the property didn't want to vacate. So we basically had to almost go through the eviction process to get the daughter out.
Yeah. So nothing to be freaked out about.
It's bad.
You should freak out if you're trying to understand it and trying to advise people. But the great thing about where we are or what we do is we're really information passers on it. We're not even really negotiating. We're passing information on to see what common ground we can have. But I'm not really selling a house. I'm not going to try and convince them to buy it. It works for you, it doesn't. Right? I don't have to wake up there every morning. You do. Do you like it? Okay, we'll do what we can. And then so you're really not, it's kind of an interesting place we're in. And it's the same thing with property management. The tenants is we should not be the ones interpreting, here's what I understand. What you should be telling your clients, say, look, there's been a lot of changes to tenant laws that really protect the tenants. And now that we're under contract, I need you to contact one of these attorneys who's going to consider it like an inspection. You need to have an attorney, make sure that we have your bases covered, and make sure we're doing this right, and make sure if you're evicting or if you're buying it correctly, both sides. And then just keep me posted, make sure we're doing it correctly. Cause we shouldn't be in the middle of trying to help people understand that, cause we don't. That's where we're gonna get in trouble, because if a client, as realtors, as a client comes back and says, well, my agent said this, and you give them wrong advice, that's called an error. Remember errors and omissions insurance? People like to come after realtors because they know they have insurance, right? Insurance companies like to settle. So you just need to be careful not to go outside the purview of your license, and advising people on tenant law is not in your license. Questions?
Thank you.
Yeah.
Can I assume we have a couple of lawyers on our vendor list?
We do, and they're all three named Kevin.
And the other gentleman that came in with Kevin Ike, his name is Pete Myers, and he
Yeah.
is a tenant law attorney.
Yep.
He's a little dry.
Yeah, we have 3 or 4 that
Yeah.
certainly we refer
Yeah,
people
so,
to.
I know.
And if you go to the vendor list and look at attorney, there's plenty of out there.
Yeah.
And I'm sure that if you ask for them, the thing you want to be careful of is you want to make sure an attorney who is familiar, not just like a GP who's never who just kind of, you know what I mean?
Right.
Because you want to make sure they understand the tenant law. And a lot of them will say they do, but maybe not. But Kevin Ike, Kevin Harker seems to know it. Pete Myers seems to know it. They've all taught classes on the subject.
Right. You can, yeah.
With George Thompson.
Who?
George Thompson.
George Thompson.
George Thompson, one of our agents?
Yeah.
What about him?
Would he know all this?
No. Make it very clear, George Thompson included. None of you should be even trying to understand this. Because as soon as you do, you're gonna give bad advice, right? You should be just saying, look, I don't understand all this. I know the laws have changed. There's a 90-day eviction, there's a 90-day notice, there's some timeframes and things that can complicate the transaction. I need you to talk to an attorney to make sure you're basically covered or doing this correctly.
Hey, Mark?
Oh, yeah.
How much is our air initial deduction?
I think it's 5, I think.
Hey, Mark?
I'd have to go back and look, I can't remember.
I know that Kevin Ike, Kevin Parker say, hey, I'm a war agent, I, saw you in a class. They will totally talk to you for free, so don't hesitate to pick up the phone and call.
Yeah, that's a good point.
Yeah.
Kevin Harker, Kevin Ike, they teach class here all the time.
Yeah.
And I use Kevin Harker in a couple things, and Kevin Ike is doing something for me, and I got a Kevin Shuba, that I use for a lot of stuff too, but I'm not sure this is his specialty.
Yeah.
But Kevin Harker, Kevin Ike, and if you mention, hey, I'm with Moore Realty, saw your class, have a question.
Right.
Then they might give you
Oh, they will, yeah, they will talk to you.
So I know you say we're not meant to understand this, but there is a box that says that we agree, that the buyer agrees to keep the tenant after closing on our form that we are responsible for filling out. And you're saying that the new law says that we cannot keep a tenant after closing. That's what, that conversation you had here. And so that is something we need to understand.
if I'm an investor.
Well, if you are keeping a tenant after closing, you would be an investor, because obviously it's turning into a rental. That's how I perceive it. What else could
I don't
you
know.
be other than an investor? So we do
No,
need to know
if I
that
intend
we
to
are
occupy it as my
responsible.
primary residence, I'm not an investor looking to hold this as a rental.
And if I have to.
I'm just waiting for a tenant to vacate, that's not an investor.
No. We would still use this even for an investor. Like if say we had someone who was buying their house as an investment, we still have to present the form and fill out one of those boxes, or have them fill out one of those boxes,
Yeah.
even if it is an investor. So we can't just put our head in the sand and say, there is a box on there saying we agree to take tenant, or the buyer agrees to take tenant after closing.
Right here.
And so.
So, yes, so the tenant is currently possessing the property, will buyer, I think that's a typo. Will buyer will accept.
Yeah.
Is that a typo, or is it just me?
No, it's a typo.
Right here. Will buyer will accept tenants at closing, check 1.
You're saying you're not allowed to accept tenant at closing, that they can't. we
No, I'm
can't
not
have
saying
it.
that.
Not you, you're not giving advice.
I'm not even saying that's what that's saying.
Okay.
I'm saying, what I'm saying, there's a part of the law that could be interpreted, that if I'm an investor to buy it as a rental,
Right,
I can't close that with a tenant in place.
right, that's what I'm talking about. And
But if
it's
I'm
like-
doing it as a primary
No,
residence.
I'm not talking about primary residence.
Okay, but as an investor, yeah, what you need to be prepared for is some counteroffers back and forth concerning this.
But is it legally allowed? I feel like there's confusion here. You're saying.
I'm fully admitting there's confusion here. That's the whole point.
But we have to have them fill this out, so it does.
Fill it
fit
out.
us.
Yeah,
Yep,
but
fill it
you
out
can
and just
tell
say,
them to
and
fill
just
it
check a
out
box,
after they talk to them.
check a box as they wish.
Yes.
And this is a legal form written by the attorneys, by ORF, right?
Yeah, and they haven't
My
updated
guess
it
is,
since law.
is that will be revised.
Yeah.
That section right there will be revised, if not a whole nother addendum's coming our way, based upon this. And I think that even ORF and the attorneys are trying to understand what to even say and do about this. Cause you're right, that's the point. Well, what about this? Well, yeah, thank you legislature.
Well, they're encouraging people to break the law then, because they're saying we'll accept tenants and we can't.
They're
by
giving
law.
them an option.
Yeah, so fill it out as they wish. That's it. And you're not breaking the law, cause you haven't closed. You haven't closed.
And then tell your client to advise them with an attorney.
And you say, look, we're gonna fill it out this way. This is what we want, but you better check and make sure that we're good to go, or how we're gonna make this work. I just think of the time frames. You have to give them 90 days notice.
No, but I'm saying they wanna keep them.
I understand. But if I don't want them, if I'm a buyer,
Right.
I'm just buying it, my rate lock, my this, my that, I can't wait 90 days. Everybody's used to a 30-day turnaround time from selling, buying to, selling and buying and moving in, right? This is window of 30 to 40 days used to working, well now it's over double that, potentially, if there's a tenant involved. So what is that gonna do for homeowners, or what is it gonna do for, landlords?
Evict their tenant.
You're gonna start doing what?
Evicting their tenant.
Upon renewal, what am I gonna do?
Sell all my property.
Not renew, and I'm gonna sell my property.
Yep.
And what does this do for available properties to rent? So it's not, I just don't know what they've accomplished here. It's an over-rotation. So the point you're making, Deirdre, is exactly why I'm bringing it up. Fill out the paperwork in the offer exactly as we have. We're gonna have an advisory addendum. This is, hey, there's potentially some things that gotta be worked out about the tenant. You need to contact a lawyer. And you'll need to work with them, and you can be involved in the conversation. You can say, okay, how do I write this? What do I do? And that's okay. But this is, don't you pay for it. This is like an inspection report. This is like an appraisal. It's like something else they should be getting when a tenant is involved. Deirdre, I don't know if it's right or wrong, but it's the form we've been given by the state to use, who was also involved, so that's what we're going to do. So don't agonize over if I'm breaking law and checking those forms. If your client does not want to take full responsibility, check, no, I will not. Seller shall have full responsibility to remove a tenant prior to closing. Okay, well, I can't get them out prior to the closing in 30 days. Okay, I need them out. When can you close? I'm not gonna close until they're vacant. It's just negotiation at that point.
No, I'm talking about the one that says they'll keep the tenant, not the getting
Okay,
rid of it.
yes, I'll keep the tenant after closing.
Yeah, that's the one that's the problem, is he
And if I'm an
doesn't-
investment, okay, look at this, right in the thing it says, use investment property addendum. That goes against some of the things in the statute. Cause now they're telling me I'm gonna accept them after closing.
That's what I mean.
And use investment property addendum, well, that isn't, to my point, which is, don't talk to an attorney, make sure we're doing this right.
When ORF gets sued, then they'll do it, because if someone buys this, and then this is in the contract, and ORF wrote the contract and it's against the law, they're gonna be the ones getting sued.
Buyers and sellers just need to get some competent legal advice when tenants are involved. That's the bottom line of this.
And that's sad. What if they don't have the money to do that? That's gonna be part of the problem as well.
It's if they don't have the money to do it, and they say, well, what do I do here, or what do you say?
Yeah.
So I don't understand the law enough to know, I'm sorry, it's
No.
so that do you have a credit card?
Yeah.
And maybe you can maybe you can get the question and call one of the guys that are sort of, not on staff, but kind of sort of been the go-to people on this stuff and say, look, I got one here, just I'm running past you, they don't have any money, can you do anything? And just see, it's just, you're pointing out exactly why you need to be very careful with this.
Yeah, that's good. Thank you. Do we know is any new amendment going on?
I don't know. The problem with this has been written for the benefit of tenants.
Yeah.
And tenants, to get this written, were very vocal about, because people raised their rents too high and they were being treated unfairly. So now it's become what do you call it?
They've made it very difficult.
Well, you say it's for the benefit of the tenants, but it certainly hurt tenants weeks before it was voted in, because landlords had to raise all their rents that weren't market value. So a lot of people were out homes then. And I wonder about that long game quite a bit in this.
As with most legislation.
Like, are they trying to get houses on the market, say, look, we fixed the house.
No, here's what I think happened.
Like, really?
remember, what does a politician always want?
Votes.
Second term, right? That's kind of what they're waiting for. And so there's, and this is not a political statement. I'm trying to make it that way at all because I don't want to do that. But there's a lot of legislation is written without thinking through all the consequences.
Yeah.
That's all I'll say.
Uh-huh.
And there's a lot of unintended consequences over time. And we don't know what they are. Right now with this one is the point. And what I don't want you guys to do is to put yourself in a place of being perceived as misrepresenting a law that not everybody understands. This thing that we talked about with Stella and the investment property, we might find out, okay, well, if you go to subchapter whatever, then there's an exceptions for this and that make it okay. And that might be. Don't over-rotate, don't feel like you're breaking the law, move forward in your transactions, defer them to an attorney. That way the attorney's on the hook.
Definitely think about what you're going to say to your clients.
Yes.
Because you don't, the worst thing, I mean, not the worst thing, the clients hate hearing that you don't know. They want the answer from you. They want the tax answer, they want the legal answer, they want the.
Well, what am I paying you for? Well, okay, you're
Right.
paying me to protect you, and this is how I'm protecting you.
Yeah.
I'm telling you that this is a very complex law that has some unintended consequences. Not everybody's even the lawyers even the state legislature doesn't understand yet what is. And so to be safe, you need to have a half-hour conversation with an attorney.
Yeah.
Here, call Kevin, whatever. They're call them on staff if you want. They're willing to take your call. It's not for free, and just treat it that way. It's like inspection, right? I don't know how a furnace works, but you're my realtor. If I don't know a furnace guy, I mean, so poor gal. So questions? I didn't mean. I was not trying to. Do not over rotate and do not flip out.
Unless you're a landlord.
Unless you're a landlord. Yeah, exactly. But if you have a buyer or a listing with a tenant in play, there are some implications that we don't quite understand, and you really should advise. Now they can make their own decisions, but we're going to have something that says we've advised you to, and if you choose not to, that's fine, but we've advised you to. They can still make decisions on their own and enjoy those risks or whatever they do.
Were you still going to put together an addendum?
I have an attorney writing
Okay,
it right now.
perfect.
Yeah, I'm not. I was trying to write it. I thought, this is too complex.
Yeah.
That Kevin Heike's writing it.
Yep. Good.
I said keep it to a page. Don't want anything big or elaborate. Just a page advisory addendum that we advise you to talk to an attorney about this. That you can just drop in. We don't have any other separate supplemental addendums as a company. We tried very hard not to do that because there's so many forms anyway. But this is one where we're going to have that for tenant and play. We just need to know that we've advised you to seek competent legal advice. Other hands in the air? Yeah, it's okay. I don't mind talking about it.
I actually have one more question.
Yeah, sure.
So if, not talking from the buyer's perspective, if the tenant is supposed to be out by closing, and at closing they are not out, and my buyer does not want to close until they're out, and it just doesn't happen, is their earnest money protected? I mean,
so if a seller has failed,
yes,
the seller can't withhold their extension. They can by refusing to sign it, but if I get near close date on any term or condition, the seller as a buyer, the seller has not met, they technically cannot withhold their extension because of their failure. They kind of have to extend. That being said, can you force them to put ink to paper? You can't. You can't force them to sign anything, unfortunately. But legally, the seller has to, if they fail to perform, they have to extend or return the money.
so the buyer would have a legitimate reason to walk away then at that point, if they want.
And it's just a decision people make. I just doing this with the client. I told some of you about this, where someone was wanting to close in 2 weeks, but we gave the tenant occupancy after closing. It's now got a new twist to it. So, wanted to close in 2 weeks. It was owned by a father whose daughter was a tenant, paying like $500 per month in right next to Nike. Is that cheap? Really cheap. And we said, great, but we will make our offer $7,000 over your ask. If the tenant is out in 30 days, we'll give you all of it. It all is released to you. If they're not out in 30 days after mutual acceptance, then half of it's released to the seller. If they're not after 60 days, the rest of it's the buyer, excuse me. If they're not out after 60 days, then the rest of it's released to the buyer. That's the way we wrote it. And he had other property, just moved his daughter out, but it took 40 days. And now at day 31, I sent the email to escrow saying, we're at day 30, after mutual acceptance, you'd have her money. And she never replied to me. What I did get was an email from the agent saying, wait a minute, that reset when we signed the occupancy addendum. Because we signed occupancy right before closing, or right after, it was just after closing, actually after closing. And so they're claiming that the timeframes that began upon mutual acceptance, in writing, upon mutual acceptance, so that's 30 days of this offer, usually of this offer. They're saying now that you signed an occupancy addendum, we reset that time frame, and it's like, how do you figure? It doesn't reset anything. So now, guess what the deposit is? So you get escrow and then go into small pay.
Wow.
Because the buyer is saying, wait a minute, I'm due half that, and the seller's, no, you're not, because the time frame reset. And I'm like, nothing reset. When we just did an occupancy, didn't cover our bases, that's it. So, and there's really nowhere for the seller to go, but now everybody's all up in arms and whatever, but that was a tenant involved. What could have happened is that tenant could have just got to the end and said, I'm not leaving. You didn't give me right notice. And now we have a buyer who owns a property with a tenant refusing to vacate. They now have a legal issue, right? Will the sheriff show up and remove them? No. Will they show up and evict them? They won't do anything like that. You can't call the police. It is a civil matter. So the buyer took an enormous risk. Okay, we'll let them stay. We'll close in 2 weeks if you do these things. Certain times she got out, right? The tenant got out. But what if she hadn't? That's a massive 15mm cannon shell that the buyers just dodged. But they're willing to take that risk based upon $7,000 potentially in play. Another buyer and seller's like, no, it's our money. Like, seriously? So, see what I mean? This is right when the tenants law passed. We're like, okay, how do we do this? That's how we approached it, but it could have easily gone the wrong way. So you need to be very, very careful. So the way you can motivate things as a buyer is I want this done prior to closing. If it's not, I'm not closing. You get the day before closing and it's not done, you say, well, we're not funding and recording until it's closed. A lot of times the seller's moved on, getting ready to do something else, they needed to close. So now who is motivated to make that happen? Usually the seller, right? So anyway, kind of rambling a bit. Tracy, did you have your hand up? It was 11? Oh, thank you, I gotta go. 11:01, I'm late.
We're gonna mom you.
We still need the list sent around too. I haven't got the list.
Okay, the list didn't make it. Kim, where's the list? Where's Kim?
Oh no, did she take?
Did she take the clipboard? Anyone see the CE clipboard?
We saw it in the site.
Somebody did, I'm gonna need her in a little bit if somebody.
Yeah,
Tell you what, if you didn't sign, which it looks like it's the side of the room, shoot me an email or Kim an email, say, hey, they didn't make it around. And don't you dare do it on camera. They're watching, right?
Yeah.
We know who's here. And you weren't. If you were here in the room, send Kim an email and say, it didn't make it around and I need the CE credit. Okay? Thank you very much for being here. Have a great weekend. Happy 4th of July and all that.
Happy 4th.
Yeah, I gotta run here. And I'll catch you in a